Next January, the trial of OUSMAN SONKO, former Interior Minister of the Gambia, will open in Switzerland before the Swiss Federal Criminal Tribunal for crimes against humanity. For the first time, a former member of a foreign government is being tried before the national tribunals of a third country based on the principle of universal jurisdiction. My name is Philippe Currat, and I'm OUSMAN Sonko's defense counsel. Crimes against humanity are defined in Article 7 of the Rome Statute creating the International Criminal Court. For the purpose of these statutes, it is stated that crimes against humanity means any of the following acts when committed as part of a widespread or systematic attack directed against a civilian population with knowledge of the attack. The list of acts described includes, among others, murder, imprisonment or other severe deprivation of physical liberty in violation of fundamental rules of international law, torture, rape or any other form of sexual violence of comparable gravity, or other inhuman acts of a similar character, intentionally causing great suffering or serious injury to body or to mental or physical health. In Article 7 of the Rome Statutes, the paragraph 2 defines the notion of this attack directed against a civilian population. That means a course of conduct involving the multiple commission of acts referred to in paragraph 1 against any civilian population pursuant to or in furtherance of a state or organizational policy to commit such attack. And the only of the individual acts that is defined in this paragraph 2 of Article 7 of the Rome Statute is torture, which means the intentional infliction of severe pain or suffering, whether physical or mental, upon a person in the custody or under the control of the accused. In Switzerland, Article 264a of the Swiss Criminal Code defines the crimes against humanity. The notion is based on that of Article 7 of the Rome Statute because it has been adopted in order to domesticate that text in domestic law. The definition is not exactly the same. According to Article 264a, paragraph 1, the penalty is a custodial sentence of not less than 5 years for any person who, as part of a widespread or systematic attack directed against any civilian population, intentionally kills another person, severely deprives a person of his or her liberty in violation of fundamental rules of international law, inflicts severe pain or suffering or serious injury, whether physical or mental, on a person in his or her custody or under his or her control, rapes a person of the female gender, or forces a person to tolerate sexual acts of comparable severity, or, for instance, commits any other act of a comparable seriousness to the felonies mentioned in this paragraph, and thereby causes severe pain or suffering or serious injury, whether physical or mental, to a person. The first time the International Criminal Court has the opportunity to define the notion of crimes against humanity, and in particular of this contextual element of the widespread or systematic attack against the civilian population, was in the German Katanga case in the situation of the Democratic Republic of the Congo. In that decision, the court stated, and I quote, "The first stage of reasoning concerns an analysis of the existence of such an attack, which entails, first, establishment of the existence of an operation or course of conduct involving notably the multiple commission of acts described in the list of Article 7 of the Rome Statute, or the list that we have also in Article 264a of the Swiss Criminal Code. Second, that the operation or course of conduct be directed against a civilian population. And third, that it be proved that the operation or course of conduct took place pursuant to or in furtherance of a state or organizational policy. In this regard, said the court, it must be shown first that a policy existed, and second, that the policy was connected to a state or an organization. The second stage of the reasoning pertains to characterization of the attack, in particular, ascertainment as to whether it was widespread or systematic. Usually we consider that an attack is widespread if it provokes a large number of victims, and that it is systematic if it is, in one way or the other, organized. The third and final stage seeks to determine, firstly, the existence of the requisite nexus between the widespread or systematic attack and the act within the ambit of Article 7, respectively Article 264A of the Swiss Criminal Code. Secondly, knowledge of that nexus by the perpetrator of these acts. For the first time, the Swiss Federal Criminal Tribunal will have the opportunity to define crimes against humanity in accordance with Article 264A of the Swiss Criminal Code. It will have to deal with this definition of that contextual element of the widespread or systematic attacks against the civilian population, and on the policy element too. There is no reason for the Swiss tribunal to ignore the international jurisprudence, and in particular that first decision of the International Criminal Court on the Katanga case that described very precisely, step by step, the reasoning to determine if there was this contextual element or not in a particular case. This is what, among other things, will be debated before the Swiss Criminal Federal Tribunal in OUSMAN SONKO'S case next January.